Well, good morning, everyone, and I welcome the government delegation. We continue with our review on cluster number 2, on the review of the Article 6 to 9 of the ICESCR. I will just let you know that we were going to do questions on Article 1 to 5, but we were told that the specialist couldn't come this morning, so we'll deal with that tomorrow morning. Okay? So we just follow as planned. Review of Article 6 to 9 from now until 1 o'clock, and then at 2:30 reviews of Article 10 to 12 of the Covenant. Okay. I'll immediately give the floor to the delegation. Please, you have the floor, sir.
Chairman, distinguished guests, on behalf of the government of the Republic of China and the people of the Republic of China, I would like to extend our appreciation to your efforts to promote these two covenants, and thank you for coming from afar. We would like to take this opportunity to make the presentation. Although we are not a member country of these two covenants and the United Nations, but we still take the initiative to host these review meetings, and your visit have demonstrated your support for human rights. And this review will be one of the most important milestones in the human rights protection. We have signed the covenants at a very early stage, which demonstrate our support for these covenants. Although we have lost our representation in the United Nations, which prevent us from participating in human rights activities in the international community. However, we still see some progress in the human rights area. This time, we host this event as an example of our support for human rights protection. We are very clear in terms of our position of abiding by the principles of ICESCR. Since we are not a member of the United Nations, we can only try our best to show our efforts, and by taking these actions, the Legislative Yuan have passed the Implementation Act on March 31st, 2009, and the President also made the announcement of the Implementation Act on April 22nd in the same year. Although the President has approved the two covenants on May 14th, 2009, however, the approval hasn't been accepted by the United Nations. We have to make a few announcements to make sure that we are trying our best to abide by the principles of these two covenants. Take the Ministry of Interior, for example. We have tried our best to follow the principles and philosophies of these two covenants. In March 2009, we have established a consultation group for immigrants' human rights. We also pay attention to the human rights of the immigrants, whether which country of origin these immigrants are from. We are trying to be fair and impartial in terms of our Immigration Act. There are certain issues that have been thoroughly discussed to make sure that the regulations and laws will not have any conflict with the two covenants. the issues that's been criticized before has been revised and improved. And the consultation group that I've just mentioned is not only formed by internal members. We have 9 representatives from NGOs and the academia. We only have 6 members from the government ourselves. This example is from the department that I'm working. So I believe other authority concerns, other government agencies also follow the same principle. And I have to highlight some of the features of these reports. Number 1, this is the initial report that we first proposed based on the format and principles for the member countries of the United Nations. It takes a full year to complete the report, and we have held 82 review meetings in the process. We have also held 4 public hearings nationwide. The report was completed by April 20th, 2012. And the President has hosted the press conference for the initial report to demonstrate our determination and commitment to promote and protect human rights. Secondly, we also like to extend our appreciation to all the parties who have contributed to the writing of this report. In the process, we have had a comprehensive dialogue with the civil society of Taiwan and listened to their recommendations of improving human rights and included their criticisms and comments in the report. We would like to extend our appreciation to the members of the Human Rights Consultation Committee and all the scholars and experts and NGOs who have contributed their opinions and comments. Thirdly, Taiwan will also, based on the conclusion of the committee, to improve the policies and regulations concerning human rights and try to protect and substantialize the rights that's been covered by the covenants. Yes, there are certain cultures and values in Taiwan that make it a little bit challenging for us to improve on the protection of human rights. The efforts we will not able to see the results overnight. We will need to be more patient to accomplish our goals step by step. Since we are not admitted as a member of the government, we're not able to be monitored and supervised by the authority concerned. And the challenging situation for Taiwan and the international community is one of the reasons that the human rights of the 23 million people of Taiwan has not been fully protected. Our commitment and efforts will not be changed, but we know that there are a lot of challenging situations and problems in the process. We hope that the constructive dialogue between us will be able to help us understand the value of the covenants and try to achieve the rights in the proper way. Thank you very much.
And, does anybody else wish to speak at this stage from the delegation on this? If that's not the case, then I hand to my colleagues. I think Mr. van Boven has a couple of questions.
Thank you, Mr. Chairman. Well, it's a pleasure again to meet with the delegation from Taiwan and to exchange certain views, particularly on Articles 6 to 9 of the International Covenant on Economic, Social and Cultural Rights. Let me just make one particular general comment, and that relates to practically all articles of the International Covenant, namely that these rights are attributed to everyone, everyone. And I think I come back to that. We should keep that in mind, that human rights are not necessarily only the rights of citizens, but the rights of all. Having said this, I selected a few issues that I think are of extreme importance in this country and also in general. I selected, in fact, 3, but after listening yesterday to impressive statements also of certain civil society organizations, in particular organizations representing the rights of the disabled, I have added a 4th issue on the question of employment, appropriate employment for disabled persons. So the following 3 issues I would like to discuss with you, and then also, but I think, as was the practice yesterday, that I will not deal with them all together, but item by item. So the first issue I would like to raise is the question of the foreign workers, migrant workers. This is really a major issue in Taiwan, but also in other countries. And I'm not referring to people who are coming here from North America or from Europe, as in whatever capacity of employment they may have, but rather to persons who are much more vulnerable than the Europeans and the North Americans, namely those who seek employment and seek a life for themselves, who come from neighboring countries like Indonesia, Vietnam, Philippines, and other neighboring countries. They are the persons who are much more vulnerable and come and seek a better life or a life of existence here in Taiwan. Now, there are various aspects relating to the position of foreign workers. I'm not saying that I will be complete and exhaustive on that, and perhaps if there are other issues relating to foreign workers, that will come up as well. But the first aspect I would like to raise is the question of recruitment, the importing of foreign workers, migrant workers. There are certain brokers or business brokers who have made it a very lucrative business for themselves to deal with that and to be involved in the recruitment of foreign workers. Now, I would like to know what the government, how it deals with that issue of these brokers, because many of them are not so much interested in the rights and welfare of the migrant workers themselves, but in earning their own money and in sometimes in an exploitative way. Even these broker fees may constitute a serious burden even after they have returned to their home countries, and they are still have this debt to these fees to be paid to the brokers, and this is a heavy burden for themselves and their families. So my question on that issue is, what is the government doing to reduce the exploitation by these brokers, and perhaps to promote the direct hiring of foreign workers rather than through the intermediary of these brokers? That's my first issue on the question of recruitment and importation of foreign workers.
Okay.
No, I have a number of. I will deal with this. I have a few more on migrant workers. This is another aspect I want to raise is the employer and foreign worker relationships. There are employers, apparently, to keep strict control over immigrant workers, sometimes withholding their passports, imposing compulsory savings, and also there are all kinds of restrictions to change from one employer to another. So I would, particularly on that issue, would like to know what are the rights of workers to change employers if the relationship of the employer and worker is not favorable. Another point I would like to raise, and that is also a sensitive one, and that is the question of the domestic workers. They are vulnerable often to sexual harassment, and there is often, if I'm well informed, inadequate overtime payment. And they have often, these domestic workers, poor living conditions. So what decisions are taken to improve their actual and legal position? I understand that there is a draft of labor protection for Act for Domestic Workers. Now, we encounter here often drafts and good intentions, but is it so that this draft will be enacted and enforced in the near future? So a draft to protect also the Act for Domestic Workers. That brings me to the issue of the Labor Standards Act. I understand that also domestic workers and others, not all workers, are covered by the Labor Standards Act. So domestic workers are not covered, dispatched workers, among others. What can be done to make this Labor Standards Act more inclusive, all-inclusive, rather than only applicable to certain groups of categories of workers, but that all workers are included under the protection and range of that Labor Standard Act. Then I would like to raise also the question of the delinking of wages of foreign workers from national workers. I understand also that also in the part of certain government ministers it was even suggested that there should be such delinking, that after all foreign workers may be paid at the level of what are the salaries in their home countries rather than at the level of the wages here in Taiwan. If this delinking would be materialized, that I think would also constitute a violation of Article 7 of the International Covenant on Economic, Social and Cultural Rights. We would like to hear that any of these proposals for delinking wages is not supported now by the government. Another issue, and it came up also this morning when we met with representatives of non-governmental organizations, that is the issue of non-documented workers. In fact, as at that time the chair said, this is we realize this is a problem in many nations, in many countries, also in Europe, but it is a real problem. And when I said a moment ago that human rights and also apply to everyone, so that includes every person, also the non-documented persons. Now, now there are, and this came up this morning also, there are certain basic rights, very basic rights, like food, adequate food, shelter, health care when needed, that are in fact so essential that no one, documented or non-documented, should be deprived of that right, of these rights. They are human beings, and often very vulnerable one. Now, again, we were told this morning that when someone, for instance, needed immediate and urgent health care, when someone is close to his life is in danger, that the government would take the position, well, we have nothing to do with that because we are not responsible and accountable as far as non-documented workers. That's their own fault, their own mistake. And so they are left to the care, if at all, to others, to non-governmental organizations. Now, I do think, I know the problem also in my own country, but then, for instance, also local authorities at least, and medical people will at least give the immediate assistance needed. You cannot leave persons, documented or non-documented, without any medical care when this is urgently needed. So I would like also to ask the government to take a certain responsibility on such an issue, which is a difficult issue, I agree. But when, as also President Ma said the other day, that we want to be here in Taiwan a nation to protect human rights, then it is also the rights of all. And so that is, these are certain issues I wanted to raise in connection with the question of migrant or foreign workers. The other issues on minimum wage, and so will be raised a little later. So thank you, Mr. Chairman.
Thank you very much, and I hand over to the delegation if you would like to respond. By the way, could you just briefly introduce yourself?
Okay. From the Immigration Bureau of the Ministry of Interior. I'm responsible for coordinating in the first session. The next question is relevant with the Council of Labor Affairs. So we would like to ask our representative to first identify yourself before providing the answers to the committee members. And we have 4 to 5 questions. Can we have our representative from the Council of Labor Affairs to answer first? Good morning. I'm from the Council of Labor Affairs. I would like to answer your questions one by one. First of all, regarding to the deprivation of the brokers of the immigrant laborers. Basically, the government is in the position of protecting these foreign workers. As for the exploitation of the brokers, we have set the charging standard of the brokers. If their fee they charge is higher than the ceiling, we will impose penalties on these brokers. We have clear regulation on that. And we also actively communicating with the sourcing countries of the foreign laborers. We also demand them to set the fee rate for the broker fee. On the other hand, we also try to avoid the situation of having the foreign workers being charged unnecessary fees. We have now initiated a validation process of the workers' agreements. all the parties concerned need to sign these agreement, and all the costs related need to be specified on the agreement. If they are charged of the fees that are not stipulated in the agreements, the government will intervene. And we also stipulate that the brokers cannot charge the foreign workers on behalf of the workers themselves. So we would demand the foreign workers to pay necessary fees themselves in order to protect their rights. On the other hand, employers will sign an agreement with the foreign worker, and the wage or salary stipulated in the agreement between the employer and the worker need to be no inferior to the contract that I mentioned earlier. Secondly, the relations between employer and the foreign worker. Some said the employers may confiscate the passports of the workers or something like that. So the regulations stipulate that the employers cannot take such measures in order to control the foreign workers. The current regulation is not as stringent as we expected, but in the future, the employers will be required not to take such measures to control the workers. And as for the transfer of foreign workers, in the future, due to certain reasons, we will allow foreign workers to transfer between different employers under certain circumstances. And the original employer, the new employer, and the foreign worker, if they can build a consensus, then we will approve the transfer of the foreign worker. And in order to prevent the foreign worker from escaping, we are now studying the possibility that as long as the employer allowed the foreign worker to leave, then the employer's rights for hiring other foreign workers will not be limited. In 2007, we have established a center to serve the employers. The service center was established at the end of 2007, and by doing that, we have saved a lot of broker fees from the employer. And we have had some statistics that can provide it to you. And thirdly, as for the domestic workers, because there is higher risk of working overtime or sexual harassment, our other colleague will report on this issue, that we are currently trying to make a draft of Labor Protection Act for domestic workers. Let me briefly explain on that. Before the foreign workers coming to Taiwan, all parties need to sign uh, uh, affidavit of wages before foreign workers enter Taiwan. The employer, the worker, the domestic employment agency, and the foreign employment agency have to sign an affidavit regarding the expenses incurred for the worker to enter the Republic of China to work and his/her wages salary. The affidavit must carry information with regard to the wages or salaries of the worker in Taiwan and the expenses accrued before entering Taiwan, and verifications by the competent authority in the source country is required. And as for the delinking of wages, President Ma and the chairman of the Council of Labor Affairs have made commitments that the delinking issue will be resolved. That is, the wages all business entities to which the Labor Standards Act applies pay to their workers regardless of their nationality may not fall below the basic wage. So this is my brief explanation on these issues and questions. Thank you.
Mrs. Dandan, to ask a follow-up.
It's a follow-up, and I'm sorry to interrupt the flow, but I might, the sense might be lost if we wait a little longer, because I would like to comment on what you said about foreign workers having to pay fees when they have to avail themselves of transferring employers. Like if they want to go from one employer to the next, there are fees that has to be paid. Please clarify, because I don't think I understood it very well. And that these foreign workers, their wages their contracts are signed, of course, before they depart their country of origin. Now, this has to do with the documented workers. My second question has to do with the undocumented workers. What kind of protection do they have? I know they're undocumented, but human rights requires that even undocumented migrants have, as my colleague has already explained a while ago, certain basic rights. What kind of protection does the Taiwan government offer to undocumented migrants who are being exploited precisely because they are undocumented? So they go from one employer to the next without any protection, without any contract on wages in particular. They are, in other words, very vulnerable to exploitation. And my third question also has to do with undocumented migrants. Is there any possibility for the Taiwanese government to provide for them at some point a regular status? Like if they are undocumented, is the Taiwan government open to the possibility of, for example, granting a regular documented status to migrants who have been working in Taiwan for a minimum number of years? Thank you.
Would you like to respond immediately? Okay.
The first question, according to the transfer of employers for documented foreign workers, after they come to Taiwan, we have set the fee standard. All the fees are included in the standard. Therefore, the workers do not need to pay any fees when transferring employers. Secondly, for the protection of undocumented foreign workers, we found that when documented workers turn into the status of undocumented workers, his or her rights and benefits will be seriously affected. We, of course, do not hope these workers to become undocumented. Therefore, we have established a 1955 hotline that if the foreign workers being treated unfairly in the during his or her stay, will like them to make the call to the hotline, and we will demand the local government to provide some assistance. this is intended to protect the rights of the undocumented workers. And as for the human rights of the undocumented workers, if they are involved in the cases of human trafficking, if they are victims of human trafficking, we have had relevant regulation. For these victims, we will allow them to stay in Taiwan and will grant them rights to work in Taiwan. These undocumented workers, if they are being exploited, then they will be able to make the call to our service hotline to file some complaints or ask for help. Thank you.
Yes, I would like to come back because I think there's a problem of communication here. I know you're trying to respond to my question regarding the protection of the human rights of undocumented migrants. First, you say that, you know, they can call if they are being exploited. Now, picture me, I'm an undocumented migrant. Would I dare make a phone call to the government and then divulge the fact that I am undocumented? One. Second, an undocumented migrant is different from a human trafficked person. So we're not talking about the same issue here. The kind of protection I'm looking at is related to my colleague, Mr. Van Boven, question. What kind of rights do undocumented migrants enjoy in Taiwan? I know this sounds very, you know, it's like they may be oxymoronic, let's say, to say that undocumented migrants have rights, but they do. They really do have rights according to the Convention on Migrant Workers. And there's hardly any distinction, except for a few, that the undocumented and documented migrants have. Because after all, when we're talking about human rights, we're not talking about the status of people. We're talking about their status as human beings. So, and I really beg to differ that human trafficked persons are really not the same as undocumented migrants. Thank you.
Thank you. Do you wish to respond?
我想刚刚提到这个非法外劳，
I talked about illegal or undocumented foreign workers. Basically, they are still protected by labor standard law. Just that their status is undocumented, but still they are protected. So, as you mentioned earlier, they might be afraid of let their status be known. So when I talked about change of protection, I was talking about, for example, there are, for example, rights enjoyed by documented laborers, but still undocumented laborers still enjoy several of the rights protected by labor standard law. You mentioned earlier that when it comes to healthcare, maybe I can ask other representatives from the government to respond to that. For laborers, for undocumented workers, they still enjoy the same rights protected by labor standard law. I'd like to also add something here. We talked a lot about undocumented workers. For undocumented foreign workers, the stand the government is taking is that since there are two terms, which is documented versus undocumented, so basically there are different treatments. But for a human being, the fundamental rights of a human being are being addressed here in Taiwan. So you mentioned also our representatives also gave you some explanation earlier. This is a news report today. It was a case that was cracked yesterday. It was a foreign worker from Indonesia. She was a domestic worker in Taiwan. Her employer was exploiting her, and her employer deducted her wage. In this case, her employer was also sexually harassing her, which is why she ran away. So in this situation, her employer reported to the police to sort of say that, okay, she ran away, but she ran away for a reason. So our police force from the Immigration Bureau in Jiayi not only set things right for her and regained her legal work status, and also we sent her employer to jail. So this was not the only case or the first case in Taiwan. We understand that there are some employers who do not treat their employees well. However, we do have systems and frameworks to help these people. For example, for these runaway workers, we first would investigate to understand if he or she is actually a victim. We have anti-human trafficking law. In this law, regarding passport confiscation, wage reduction, are all behaviors that are regarded as illegal and violation of the law. So we ask our investigators to first identify or establish the fact whether this runaway worker is a victim or not. So in other words, there might be criminal or administrative liabilities of this runaway employee. However, because he or she runs away due to bad treatment from their employers, then we will give further analysis to that. You mentioned that these people may not be brave enough to call the authority. In Taiwan, people know that if you report to the authority about mistreatment of an employer to their employees, the government would definitely investigate. So if we know that these foreign workers are victims, they're not criminals, then we would provide them with a shelter and protection or placement. If this person needs work, we can also ensure his or her right to work. We will also issue them permit of residence, and the permit can be extended as well. So there is a mechanism established here. In the past, we did see cases. For example, a week ago, the immigration agency had a case where there was an Indonesian worker who was having a baby, actually. She lived in a very small place, and she didn't have any money. So the immigration agency actually made donations and money donations, as well as milk powder or baby formula. So not only Council of Labor Affairs, but also a lot of government agencies that take care of foreign labor issues in Taiwan. For example, later on, we will talk about sexual assessment or sexual assault. We also have foundations that are involved in this kind of issues. So there is no just one single agency in Taiwan that deals with foreign labor issues. Actually, many of the government agencies are involved, and also mechanisms are established here. So maybe also there is a law of protection for domestic workers. We paid a lot of attention to healthcare to foreign workers. I'd also like to add something here in this regard. Yesterday, I visited a department in the immigration agency. I understand that a lot of foreign workers who make money here in Taiwan and are able to afford their healthcare cost. So it's reasonable. However, if for foreign workers who do not have money for their healthcare, for example, if they come from Indonesia, then we would go to the representative office of Indonesia to take care of partially of his medical expenses. And also we have a budget from the immigration agency to cover that. And also we have budget for charity. For example, some of the cost is actually taken care of by the healthcare organizations or hospitals. So there is a network that helps with this kind of issue. So I don't think this is a big problem here in Taiwan. So thank you.
another set of questions, and I give the floor to Professor Alston, Philip Alston. Please.
Thank you, Mr. Chairman. Let me first of all just follow up on the discussion that you've been having on migrant workers. Migrant workers are, as Professor Van Boven said, a problem in every country in terms of the treatment that they receive. I have no doubt that Taiwan is taking a lot of steps to address specific problems that arise. But it does seem that, particularly in relation to complaints about labor conditions, the situation remains problematic. That the ability to go to a court is purely theoretical. The likelihood that a complaint will lead to dismissal is very high. And so I wonder if there is not room to consider a new mechanism which would provide a less formal avenue for the registration of complaints by migrant workers, combined with some sort of conciliation service. In other words, rather than turning these immediately into legal disputes, which will usually result in dismissal or deportation, there could be a less formal mechanism set up in one of the relevant ministries to deal with such complaints. Because it does seem, based on the information we have received, that despite all of the initiatives that you describe, there remains a significant area which is not being addressed effectively. Should I?
No, I come back to you once we've had the answer.
Okay, good.
To this particular. And just for you to know, Mrs. Heisoo Shin wants to raise issues as well later on women and the labor force. Okay.
I am from Council of Labor Affairs. In terms of the rights of domestic workers, I'd like to add something here. We talked about why most of the domestic workers are foreign workers or migrant workers, and why they are not under the protection of labor standard law. The scope, if labor standard law applies to all workers, then there wouldn't be a division of domestic workers versus foreign workers. For domestic workers, they are not under the protection of basic standard law. It's because that Taiwanese basic standard labor basic standard law was established starting from factory workers. So it considers that the employers are capable to take care of the rights and protect the employees. And for domestic workers, the uniqueness about them is that usually the employer only hires one worker, or it could be just help between family relatives. In recent years, we invite or recruit foreign workers to be domestic workers. in terms of practice, if labor standard law applied to domestic workers, then labor standard law would require these less advantaged employers to fulfill all the responsibilities similar to the responsibilities of a, for example, factory owner. So we have done a lot of communications with NGOs and the private sector. Our conclusion is to set or to draft a law specific to domestic workers. For example, domestic worker protection law to state, for example, basic wage, leave or regular leave, and special leaves. And basically, these regulations or articles will be identical to that of labor standard law. And also in that law, it also requires the employer to get insurance for the employees of domestic workers. So the draft of a Labor Protection Act for domestic workers is now being reviewed in the Legislative Yuan. So we hope that the law will be passed very soon. And for domestic foreign workers, for these source countries, also have regulations on employment contracts, and the employers are required to sign these contracts, and Council of Labor Affairs is also monitoring the honoring of the contract very closely. Thank you.
Back to Mr. Alston for the next set of questions.
Thank you. That just to follow up very quickly, that was a very helpful answer. The point that I was trying to make is that for the reasons you describe, domestic workers, and particularly domestic migrant workers, are especially vulnerable. And one issue which you are in the process of addressing is to establish legal coverage for this additional sector. But the second issue that I was getting at is that because of the particular vulnerability of this group, they are never going to be in a position to assert rights in the same way that more organized employees in proper enterprises are able to do. And for that reason, it might be useful to consider setting up some more systematic but less formal mechanism for trying to resolve disputes. I just put that as a suggestion. So my second question then goes to, and maybe my colleague Heisoo Shin would like to follow up on this, because I want to address the labor market issues in relation to gender equality. Falling birth rates in Taiwan are clearly a major issue for the labor market, which of course is why we have been discussing migrant workers. Your birth rates are low and seem to be dropping. One of the key issues that points to is the situation of women in the labor market. If the labor market is not woman-friendly, they are less likely to be able to combine work and motherhood. We have received information that the average relative pay rates are something like 82% for women. In other words, 82% of the equivalent earnings of men in the same jobs. But there are also questions that have been raised about the length of maternity leave, that it remains at just 8 weeks generally, that there are no other arrangements made to make it more attractive for women to combine motherhood and retention of their jobs. And finally, there is apparently a recognized shortage of childcare from birth through 5 years of age. So what I would like to do is just to draw those different issues together of the falling birth rate, the needs of the labour market, but the apparent failure to take any additional steps to make the labour market more attractive to female workers, and to ask then what specific proposals, if any, have been drawn up to address these problems and how they might lead to an improvement of the status of women in the workplace.
Whether Heisoo might add, or yeah, okay. So I give the floor first back to you, and then I come to.
Yes, in response to your first question, let me respond. On behalf of Labor Affairs Council, for a more systematic or an informal mechanism to resolve the disputes. As you mentioned, some foreign workers worry that when they make some complaints to the government, whether they are worried whether they will be treated unfairly. So, firstly, before the workers entering Taiwan, we will host some training or orientation sessions to help the workers understand the laws and regulations in Taiwan and the compensation or fee they are entitled to receive or pay. So this is the orientation session that we will host for them. After they enter Taiwan, we'll do two things. Number one, we will have welcome service at the airport. We will pass a brochure to these foreign workers to help them understand the laws and regulations and issues they need to pay attention to. And during their stay, we also, as I mentioned, established the 1955 service hotline. If they are treated unfairly or need some consultation about the laws and regulations, they can call this hotline. So far, based on our calculation, we will receive around 20,000 calls every month from the hotline. And some foreign workers in order to prevent the situation that the employers send the foreign workers abroad before the termination of their contract, the laws and regulations stipulate that the employer need to go to local government before canceling or terminating the contract, and the foreign workers will be able to also file their complaints at the airport, and we will then pass the complaint to the local government to handle these cases. And Professor also mentioned that if we can establish an informal mechanism that will be good. And at local government level, we have staff members providing consultation services. Many of these cases are actually handled by these staff members at local government level before transferring to the hotline or the consultation desk at the airport. These informal procedures at the local government level will be able to help us resolve part of the disputes or questions. And many of these disputes are handled successfully through these mechanisms. Only a small proportion of cases will come to the Council of Labor Affairs. So this is what we are having at the moment. Thank you.
Very helpful response. You say 20,000 calls every month. Do you have a breakdown of the outcome of those calls? In other words, what percentage of those calls lead to any specific action?
Yes, as I've mentioned, that we have 20,000 calls per month. We have has some summaries of these calls. For cases of complaints, we will pass these cases to the local government, and we will document the results of these cases to see whether the case has been successfully resolved. And currently in our system, we are doing that at the moment. Thank you.
Correctly, that you are setting up some monitoring system to see whether what happens with these 20,000 cases per month, but you're still in the process of setting up the evaluation process. It's not there yet, is it?
I think the information you've given us again is very encouraging, but in order to be convinced that the mechanism is working, we would need to get some statistics. In other words, not an assurance that important cases are referred to local authorities. Local authorities can ignore the case, can close it very quickly, can tell the migrant worker that they should shut up unless they want to be thrown out of the country. Do you have any statistic to indicate the number of cases of those 20,000 that are resolved in any particular way? And the Chair's question is there any system for evaluating how effectively the local authorities respond to the number of cases that you pass on to them?
是，我在做
Let me explain further. Among these 20,000 calls, a majority of them are consultation cases, and few of them are about complaints. For the complaints, we will pass them to the local government. Of course, we will not allow the local government to threaten these workers that if they do not shut up, they will be thrown out of the country. Through the hotlines, we will know maybe these cases are concerning about the disputes of compensation. Then we will ask the local government to make sure that the employer pay the right amount of money to the workers. And as for the statistics, we shall be able to provide to you after the meeting whether the cases are closed and the results, what will be the results. We have department concerned documenting the results, and we will be able to provide them to you after the meeting.
Very helpful explanation because it helps us in the assessment of what. And as far as statistics are concerned, we are normally not interested in sort of one-time statistics, but sort of how things have changed over the years. Whether there has been an improvement, on if there hasn't been, there can be very good reasons why they couldn't be done to have them broken up. But since this is the first time we've done it, in a next report, we would expect sort of broken down statistics on these things. But thank you very much for those answers. I now, you have some more questions? Or should I let?
Well, the delegation hasn't addressed the questions I posed on women and the labour market yet.
Yes, women and the labour market. Please, you have the floor, sir.
主席、各位
Chairman, distinguished members of the committee, I would like to make the response on the issues related to female workers. As mentioned earlier, the compensation, the wages or salaries of female workers is significantly lower than male counterparts. Take 2011, for example, the difference is 17.6%. But in 1989, the number was 22.3%. In other words, we have seen the narrowing of the gap during the past 10 or 20 years. The gap in Taiwan, compared with other neighboring countries like Japan and Korea, the number is relatively low and is improving. For people who entered the labor market for the first time, the compensation difference between male and female workers is only 10%. And as for the issue of maternity leave, and Chinese people, we have the tradition of 1 month of rest after giving birth to babies. That is the local tradition. However, the Labor Act, Fundamental Act, goes that the maternal leave is 8 weeks. After delivering the child, the worker, the laborer, will be able to receive 1 month of salary during the maternity leave. And if the according to medical advices, there's a need for the worker to take a longer leave, then she will be able to receive a longer period of leaves than originally stipulated. And as for the balance between work and maternal responsibilities, the new regulations that workers who is caring for a child under 3 years of age and who arrange for unpaid leave and opt to continue participating in the scheme may apply to receive an infant care unpaid leave subsidy of 6 months of wages. And according to female workers, the law stipulates that the workers, once pregnant, is entitled to the right to be assigned to jobs that are less labor intensive. And the workers is also entitled the right to take 30 minutes of breastfeeding time twice a day. And for the for these mothers have the need to take care of their children, they also are entitled to the right to negotiate with the employers to reduce their working time per day. And so basically that is the laws and regulations that we have right now, whether we need to extend the maternity leave or to take other measures. The government is actively discussing the possibilities, and part of the policies will be promoted by the Ministry of Interior.
Do you have paternity leave? Oh, yes, you want to answer more. Okay.
大家好. Good morning. I am Ms. Su from Bureau of Vocational Training. I'd like to talk about the efforts that the government has been doing. There is a law. Basically, there are 16 items about against discrimination, one of which being about genders. So there is a certain mechanism to review. Should there be any discrimination acts, then there is a fine. According to our data in 2011, we have about more than 300 cases. Only 64 of them was established. Among the 300 cases, 48%, almost half of them, are about gender discrimination. So from the data, you can see that there are more and more people knowing that there's such a channel for them to fight for gender equality at work. Professor Alston talked about gender equality issues for males. In our law here in Taiwan, back in the old days, we basically offered assistance to vulnerable women or women in disadvantaged status. For example, or families in hardships. These are targets that we help as our help of a priority. But now we have modified the law to provide assistance to families in hardships, including for both men and women. And also there's another law for family with a single bread earner. So in the past, we provided assistance to a family where only women was the bread earner, but now we extended that or expanded that to also cover men.
I'll give it to Heisoo, and then you have your other 2 points.
Including childcare 0 to 5.
Yes. Heisoo.
Excuse me. 这边是不是可以请儿童局
I'm from Child Welfare Bureau. May I also say something here? Good morning. I am Mr. Wu from Children's Bureau in Ministry of Interior. I'd like to talk about welfare for children from 0 to 5. Our child care policy is to provide monetary assistance as well as child care, so that parents can choose which one to get. For children between 0 to 5, our representatives from Council of Labor Affairs mentioned that we provided child care subsidy, and for parents who do not work but only take care of children, we also offer subsidy. For parents who are both workers and have to send their child to babysitter or a child care facility, we also offer subsidy for their child care. And in terms of child care service, for children between 0 to 2, we provide home care service. So basically, the service is provided by a child care facility center, and we can accommodate many children, and they can actually, and the parents can claim 50% of the child care expenses as their subsidy. As for children from 3 to 5 who can go to kindergarten, and we also provide subsidy for children at 5, we basically waive their tuition. And these subsidies are provided by Education Bureau, and we're able to accommodate 80 to 90% of the children. Thank you.
Thank you very much for your information, which helped me to understand further. Professor Philip Alston have raised the basic questions, but I would like to add more. And I think China, Korea, Japan, Taiwan share very much similar tradition and culture. So I can understand the situation of women who are working, who are raising children, in Taiwan as well as in Korea. And as one of the delegation said, it is correct that Japan and Korea, there is even higher income gap, wage gap between men and women. So I think compared to Korea, Taiwan is better. But before we talk about wage gap, I think the fundamental question that we need to raise is the employment rate for women. What is the economic participation rate for women in Taiwan? And I think in that case, Taiwan is a little worse than Korea. Korea is around 50%. So 1 out of 2 women is not working. And here in Taiwan, I got the figure from your report, which is around a little less than 48%. So there is a lot more room that you need to really improve because to get a job is the fundamental thing. And how you structure your labor policy, your welfare policy, child care policy really determines whether women can work, can get a job at the labor market or not. And I think Taiwanese women is as smart as Taiwanese men, maybe smarter than Taiwanese men, and very productive and very active. So if the employment rate for Taiwanese women is only 47%, there is a problem, in your labor policy, in your welfare policy, in the government policies. And I came here 2009 to review your first report to the CEDAW, regarding CEDAW convention. And at the time, there was a lot of excitement among women participants how to structure your government agency to deal with gender issues. So I had great expectation. And now, 3-4 years later, now I find that situation has not improved, much. And in that sense, I would like to raise first the fundamental question. Is your labor policy, of the Council of Labor Affairs, do you consider women as a productive force? And how do you include women? What is, because if you consider the main mindset, mentality is, okay, man is the breadwinner, women are supposed to be at home, and then whole labor policy is structured under that mentality. No matter how much additional measures you would come up with, the problem will not be solved. You should fundamentally deal with women and men as both equal participants in the labor market. So that's my fundamental question. What is your government policy? Because the reason why you consider women as somebody who take care of the family and children is whenever there is sick in the family, elderly and disabled and children, women would be there. Yeah, because someone should be there. And unless you build a whole government policy, who is going to take care of the disabled people? who is going to take care of the elderly when they are not, movable and needs care? How do you deal with child care? How do you deal with the system when there is a sick person within the family? So unless you restructure the whole thing based on all these people who needs care, how you structure this? Otherwise, usually it is especially in East Asia, it is women who are going to take care of that. No? So that's my first question. Is your government policy deal with that? Second question is, you gave information about childcare, and then even 30 minutes break for breastfeeding. And that's possible only when there is childcare facility so that woman can bring the child and then breastfeed during the break time. If there is no childcare facility in your workplace, that's not possible. Does your law make obligatory for the companies, for the workplace, to have childcare facilities? And does it apply only to number of female workers, certain number of female workers? Or does it apply to whether it's men or women, which have, for example, 200 employees? All the workplace companies which hire more than 200 employees, I'm just giving you example, I don't know, then there should be childcare facilities. So it is whether the father or mother who bring the child to the workplace so that the child can be taken care of by this. So what is your law, obliging the companies? It's just not to leave the issue to the employer and employee negotiate in between, but what is the whole structure of government providing childcare facilities? Whether it is required at the workplace. And you mentioned that from 0 to 5, the children are taken care of, and then the subsidies are given. And I got information that there are very few public childcare facilities with good qualities and less pay. And if you leave the childcare work to private childcare facilities, which is costly and you cannot rely on the quality, so what is your plan to increase good quality childcare facilities, which is essential for dealing with this issue? And then the third set of question is regarding maternity leave. And I know that it's 2 months. 2 months might be okay, but of course 3 months would be much better. And ILO convention requirement is 14 weeks, actually, more than 3 months. Yeah, so that's the international standard. And then I wonder how men deal with this issue of childbirth of their wife, and also childcare issue. If I know this because in East Asia, it is men thinking that, it's a woman who is better taking care of the children. So children are better raised by mothers at home, whether, and it's not men's responsibility at all. Men has nothing to do with childcare issues. And is it 3 days or 5 days or 2 weeks of paternity leave? In Korea, it used to be 3 days only, so that's when the woman goes to the hospital and then get out of the hospital, and then man has nothing to do with, just wait in the hospital for the woman to deliver the baby, and then when come home, the paternity leave is over. Yeah. Now it is extended to 5 days. So how many days does Taiwanese men paternity leave? Yeah. And then after that, parental leave. Yeah. Can Taiwanese men, take paternity leave like parental leave? Take care of the child. In Korea, it's only 2% of the men who apply for the parental leave. Yeah? If I look for the good policies of the Western Europe, especially the Scandinavian countries, they provide parental leave for fathers exclusively. So if men do not use that parental leave, it just disappears. So that increases men's use of parental leave, like up to sometimes 50%, you know, so that men also learn how to take care of the child, enjoy the joy of raising the child, which men lacks, you know. My question is, how do you deal with this issue of balancing work and family for men? You know, this should not be only the issue of women. It should be also the issue of men if you desperately want to raise the fertility rate. Thank you.
Thank you very much. And just on a small point, in my own country, in Germany, it's quite revolutionary. It's not like in Scandinavia that only parental.
In addition to
yeah.
mother's parents.
Yes, but now all the youngsters, when children are born, the fathers take parental leave, and they get quite a long time off, up to 1 year. They can do it, and then have guarantee of re-employment during that time. So, but that's also cultural and things like that. But there are big changes in perception on the family. So I give the floor back to the delegation. Who would like to speak? Please.
Okay, I would like to respond some of the questions as you mentioned earlier. For men, do we have any similar measures for men? In current regulations in law, as mentioned earlier, we have this. The male can ask for paternity leave of 3 days, and the employer will pay the wages of the 3 days. And as for the parental leave, male workers are able to apply for 6 months of parental leaves, just as women. If a family with a newborn baby, the mother will probably apply for the maternity leave and then the parental leave, a total of 8 months. If the husband would like to apply for another 6 months of leave, he can also do that. So the parents can take care of their baby for at least 14 months, and the male worker can also apply for the subsidies during the period. And male or female, they are able to, they're entitled to 7 days of family leaves every year. They can use these leaves to take care of their children or other family members. The employers may not reject the application, and after the parental leave, some employers will not allow the worker to return to his or her position. Then they are able to file a complaint. We will then, when it go into the procedures, we will have experts to review the cases to see whether the employer has the position or reason or the foundation to make the decision or not. And women, their professional careers may be interrupted in certain period of time. Therefore, their participation rate will be different from male workers. And with this regard, the government is trying very hard to narrowing the gap so that female workers can have a fair opportunity to participate in this in the employment activities. Some may argue that the rights and benefits of the children of these female workers may be affected if we emphasize too much on sending these female workers back to work. But our position is that raising children is not just the responsibility of the mother, but also the father. It should be the responsibility of both parents. So these regulations should be fair or impartial to both genders.
Okay, you have the floor.
And I would like to answer some of the questions, not from my responsibilities position, but from the position as a female. Yes, women in Taiwan were very hard with higher education. Some men even complain that female are having better opportunity to receive better education. We work very hard, and the employment participation rate is around 50%. We try really hard to get the number past 50. According to the latest number, at the end of last year, the number is 50.1. That is a little bit better than we hoped and than we expected.
Okay, thank you very much. And there's a very quick follow-up from Heisoo Shin.
Well, actually, the economic participation rate, the employment rate you gave me, is different from this statistics that we got from your report, which is still around 48. No, yeah. So anyway, if that's true, that's an improvement. But my follow-up question is, when you said that men, the father, can take parental leave up to 6 months. How many percentage of men are taking that leave? That's my first question. And then second one is, you say there is subsidy during the parental leave. So how much is that subsidy, monthly subsidy? Is it a percentage of the wage that the man used to receive, or is it a set amount for each month? Because that's very important. Yeah.
您现在可以回答吗？好的。According to the numbers by the end of 2011, we have more than 111,000 people applying for parental leave. Among them, 82.9% are female, 17.1% are male workers. As for the parental leave, the compensation comes from labor insurance. That basically is decided by the wages insured. According to the amount of the wages insured, they will be able to receive 6 months of compensation of 60% of their original wage or salary.
Well, thank you very much. I'm deeply impressed with the data that you have at your fingertips. That's really helpful for us. I just have a very, very short follow-up question. Looking at Ming-Li Kuo, who indicated, and what you said earlier, that maternity leave is only 3 days. What is the rationale? What's the paternity? What is the rationale for such a short term? How is it explained? Because it doesn't really make sense.
I think that is for common practice in Taiwan. During labor or the delivering of baby, basically the mother will discharge from the hospital in 3 days if everything goes right. The labor law has stipulations for specific leaves for the parental leave because the employers are required to pay in full compensation for the workers. Therefore, the number of days may be limited because we hope to promote these concepts gradually. So, and there are also other leaves, for example, annual leaves, paid annual leaves. The workers shall be able to make use of their annual leaves of 7 to 30 days to be used for this purpose.
I was really getting at the question of maybe you don't need more because you have such rich availability of domestic workers. I'm coming back to Professor Alston on Article 9, I believe, on Social Security and the Social Protection Law. Perhaps you could put your questions now.
Thank you, Mr. Chairman. The next issue I would like to raise is a controversial one, I'm sure, particularly with this group, and it concerns the pension reform that is currently under discussion. The right to Social Security clearly includes the possibility of retiring on an adequate income. I want to raise the difficult question, given the nature of my interlocutors here, of the differential impact of the proposed reforms on public versus private sector employees. My understanding is that the reform proposal announced very recently by the President would result in no significant diminution of the pension entitlements of public sector employees, but would result in a significant reduction for private sector employees. In other words, the impact, the privileged position of public sector employees will be protected from any significant impact by these very necessary reforms, and most of the burden seems to fall on the private sector. There is also the difference in timing, that the pensions for the public sector will not be affected until 2016, and then there will be a rather gradual transitional period, whereas for the private sector it's apparently envisaged that these reforms will begin next year. So my question is, given the apparent acceptance within the entire community that pension reform is necessary, on what basis does the government justify the differential treatment of the two sectors?
I give the floor back to the delegation.
Council of Labor Affairs, I'd like to respond to your questions. For public versus private sectors, we have to divide it also into state-owned enterprises or government agencies. I think for state-owned enterprises, basically we also apply the same regulations. The reform this time is all about labor insurance. There are several factors in this. On the one hand, we have preferential compensation with a lower premium. As you mentioned earlier, Taiwan has the lowest birth rate, so the sustainability of labor insurance is actually in question. So since the end of last year, including our president as well as the executive yuan, have begun to pay great attention to this. So we believe that the insurance reform should not only cover labor insurance, but also covers insurance of the public sector. So we have come up with reform and a couple of principles of the reform, one of which being sustainability. We also hope that through the system, we'll be able to protect the livelihood of our laborers after they retire. And we have come up with several reform measures, and we're more than willing to communicate with different sectors in society because this impacts basically everyone in society. So we are very willing to conduct dialogues with every sector. And it is not mutually exclusive between the private versus the public sectors because all of the retirement funds are separated. They're not pooled together. So for labor insurance and the funds of the government sectors are basically two separate things. And the premium as well as the percentage borne by the employer, the percentages basically are different. So the two systems are not interfering with each other or correlating with each other in any way. So we're hoping to come up with a reasonable system. No matter it's a private or public sector, the replacement rate, we hope to be the same. As you mentioned earlier, we seem to have a preferential rate for the public sector, but very low rate for the private sector. We have been taking these factors into consideration. Thank you. I'd also like to ask a representative from the examination yuan to say a few words. Good morning, ladies and gentlemen. Regarding pension reform for both the private and public sectors, I'd like to give you an overview about the reform in public sector. Pension basically includes two things. The first is retirement pension. So in before 1994, it was the old system. So basically, the government covers everything. And after 1995, the new retirement system is about the government taking up 60%, whereas government employees taking up 35%. So the rate is 12 to 15, and right now it's 12. And before 1995, there is public insurance. And this also involved the issue of preferential saving. So basically, there are two retirement systems, one old, the other new. So we seem to have a higher percentage now. So one of the purposes of the reform is to address society expectations. We also try to restore justice here. So in the new system, we've established a fund. And there are management issues and issues of physical burden. Income replacement rate, if it's too high, then we wouldn't be able to afford it, which is why we need to do the reform. Our reform this time, we basically look at 10 to 15 years of salary. And for the old system, with a preferential saving interest rate, and we will basically gradually reduce that interest rate from 12% to 11 all the way to 9. And the compensation used to be twice of the basic salary, and we will reduce that from 2 to 1.9 all the way to 1.8. That's our initial plan. We also thought about communications with society and government employees. So the Executive Yuan and Examination Yuan have organized several seminars and workshops to engage in face-to-face dialogues with government employees, so as to reduce resistance to the reform as much as possible. Thank you.
Wish to speak? Yeah. I have a follow-up question from Mr. Alston.
Well, I don't want to pursue this too much, but the various comments that have been made provide some indication of the actuarial foundations for the proposed changes, but they do not address directly the question of the public-private differential and the justification for that. Nothing that you have said addresses that. Even the reduction of the differential savings rate for public servants from 18% down to 12% and then gradual diminution. This, of course, is a benefit, a privilege that private sector employees do not have. But I wasn't, in other words, you public sector employees have earned 18% in the past interest on their savings, while general interest rates are 2% or whatever. But I'm not focusing on that. I'm just focusing on the details of the President Ma's announced reform plans and the very significant differentials between the public and private sector. And I'm just, maybe there is no answer that can be provided except at a political level for that question, but it's an issue.
And if I might just add, you probably are aware of General Comment 19 of the Committee on Economic, Social and Cultural Rights on the right to social security, where the various forms of social security are analyzed and that they have to be seen as a mixture of various things, social insurance, social security, and the underlying philosophy being the social protection floor as the ILO has produced and has because that when you move from a universalist system, the public system, to a mixed system whereby you have partially a universalist and partially private, then there is a danger that a lack of social protection for some are concerned. I think you answered in your answer you gave a little bit of information, but are you addressing that problem, and what are the proposals that you're doing? I mean, it's a new reform, but are you aware of these problems, and what are your suggested dealings with that? Thank you. Please, you have the floor.
因为我们
We understand that public sector and private sector basically pay their insurance premium on different bases, which is why we cannot really make apple-to-apple comparison here. The purpose of this reform is to ensure sustainability of pension fund, so that in the next 30, 40 years, the fund can continuously be paid to the retired people without being bankrupt. So my response was mainly about the initial ideas of the reform. And in the future, we will organize many dialogues and workshops with government employees and government retirees in order to modify the reform, to get their opinion and modify the reform, so as to come up with the most optimal and reasonable reform plan.
Do you have some more? No. Then I...
Well, I have others, but I'd like
Okay, okay. I now give the floor back to Professor van Boven. He has a whole range of other questions. So if you would put a question now.
Not so much in whole range, but I do have a few questions. One is, I mentioned that already at the beginning, that the issue of minimum wages and the poverty gap in this country. At the moment, I understand it is an issue of public discussion, and also I think in the newspapers and elsewhere this issue is being raised. It's not a new issue, and it should respond, the whole question of minimum wages, to also to the standards proclaimed in the Article 7 of the Covenant on Economic, Social and Cultural Rights, where so a decent standard of living for workers and their families. Now, I understand that also the government itself is not happy, is not satisfied with the present situation. I'm looking at the government report, and I quote from that. It says, well, the basic wages were adjusted already on the 1st of January 2012. And it states in its government report, the basic report on economic, social and cultural rights, and I quote, "It remains impossible that this level of wages, the level of wages as it actually is," I don't have the exact amount here available, but they are mentioned in the report, but it remains impossible that this level of wages is sufficient for workers and their families to maintain an adequate standard of living at this time. That is the government position. It's self-critical of this present situation. And then it's paragraph 81, and then it follows also in other paragraphs, majority of individuals in sheltering employment earn less than the minimum wage, so even they fall below the minimum wage, and individuals with disabilities generally receive lower wages than those without disabilities. That's also stated by the government. Now, let me also dwell a moment upon the issue of the wages and access to employment by the disabled. We had yesterday, I wanted to bring this up as a separate issue, but I link it with this one, Mr. Chairman, because also for time constraints. Now, we had yesterday very impressive statements, presentations by the representatives of disabled persons and the disabled persons themselves. They are, the disabled are in a position, of course, that is well known, not only in this country, but in many countries, in most countries. And that is why the United Nations, in fact, also drew up a convention on the subject for the rights of disabled persons. We have been discussing that already earlier, and also the question of importance that Taiwan would accept the obligations under that convention. We have many groups of indigenous people who made strongly that plea. But they are in a disadvantaged position also as far as the right to work and employment conditions. And what came up time and again was the right to access in many ways, access to locations, buildings, cultural life and what have you, but also on the right of access to employment. And and I would quote here also the general comment number 18, Mr. Chairman of the Committee on Economic and Social Rights, that states, and I quote again, must take measures enabling persons with disability to secure and retain appropriate employment and to progress in their occupational fields, thus facilitating their integration or reintegration into society. Now, coming back not only to the rights of the disabled, but in general to the issue of minimum wages and the poverty gap, is the government in handling this issue taking into account the requirements of the International Covenant on Economic, Social and Cultural Rights, in particular Article 7, because in itself they realize that the present situation, after all, Taiwan is not a poor country. I think it isn't. It is in this region. It is seen as an industrial and industrialized and developed, highly developed countries, not counted among the poorer nations. So I think they have to live up to the UN standards, but also to the standards which may be expected from this country on the issue of minimum wages. So I would like to invite the government delegation to give its views on this matter.
Thank you very much. Perhaps the delegation would like to respond?